be seated.
Thank you, Your Honor.
You're welcome.
I remind you of my age.
And how old is that now, Mr. Harpootlian?
Really? On the record? I'm old, okay?
You're not under oath. You're not under oath. All right, do I have everybody? Okay. Mr. Waters, you got everybody at your table?
Yes, ma'am, I do.
All right, then let's proceed with the defense's motion to transfer venue, please.
Your Honor, let me at the outset, we've attempted to try to negotiate something with Mr. Waters, which has not been successful. But the only person in this courtroom that has a constitutional Sixth Amendment right to a fair trial is sitting right there. Now, the state has some due process concerns. If we wanted to try it somewhere that was totally, for instance, inaccessible, we wanted to go to Oconee County.
I'm going to be there next week.
Well, hopefully you'll get back. But, we understand that. But they don't have, beyond that due process right, any pick, if you will. They're not entitled to the venire they would like to have. The venire we have to have is the venire that's the fairest to him. The venire we have to have is the one that's more likely to either have not formed an opinion, or if they have formed an opinion, it's such that they could disregard it and base their verdict on what you tell them and what comes out of that witness stand. That's black letter constitutional law for the last 200 years. Now, this is a complicated situation because the media coverage of this has been, in my experience, unprecedented for a number of reasons that go beyond just the fact of the notoriety of the case. I tried a death penalty case in Newberry County 25 years ago, covered gavel to gavel by Court TV, watched all over the country. There was no social media, there was no internet, there was no, we actually had newspapers where people got their news. And
Social media wasn't invented then.
wasn't even invented yet. We had three networks, three television stations. And it got some notoriety. It was a pretty famous case. The son of the Episcopal bishop of the state was charged with murdering his wife, who was the daughter of a state senator. Got a lot of coverage. And Henry Floyd heard the case and had a jury from Oconee County seated. We didn't even have because of everybody in the county knew one or the other. So I've been through this process before, but the most notice it got was I get a call from somebody from Arizona who watched it, and when I got back to the office telling me what I'd screwed up that day. But nothing like what we've seen in this case. Wall-to-wall coverage, internationally, nationally, and the state, when you start talking about, and they talk about media markets, it's irrelevant. Whether you're in Greenville or Charleston or Beaufort, it didn't matter. It permeated everybody's consciousness. 10 million people watched this, and if they didn't watch it live, they watched it on YouTube or Court TV that night, or with the feed on their phones. It just permeated everything. So what's the solution? Well, first of all, I don't believe the state is arguing we should go to the 14th Circuit and try to pick a jury. And we have enclosed a copy of an order issued by Judge Kelly, I think yesterday or the day before yesterday, in a civil case where the defendants in that case, with a lot more resources than us, developed all kinds of factual bases as to why that case, which is related to the boat death case, the Parker case, should not be tried in the 14th Circuit, and he moved it to Spartanburg. And we would ask the court to allow us to introduce all the exhibits relied on by Judge Kelly in that matter into this matter, so that Your Honor will have the ability to review all those. We'll get them and get them to you if necessary. There's statistical studies. Judge Kelly's order is a work of art.
I read it yesterday.
And like you, I think you probably would agree with me. Well-reasoned, factual basis is extraordinary. And that's a civil case where,
Right.
you know, there is no Sixth Amendment right on either side. So I would say, and I don't believe anybody's going to seriously argue that we go to Colleton County or even Beaufort County and try to pick a jury and waste our time down there. That's number one. So where do we go? Now, we suggested Charleston. And why did we suggest Charleston? A whole number of factors. One is it would be convenient to the 30 or so or more witnesses from Colleton County that will be testifying in this case. They won't have to travel, go somewhere, spend overnight, or travel 4 or 5 hours in a car one way and back. That's number one, convenience to witnesses. Two, the jury pool in Charleston is larger than the entire jury pool for the 14th Circuit. More people. And why is that important? Because once we got through the questioning of the hundreds of jurors that were brought into Colleton County, only 14% remained. 86% went away. And so if you're going to have to bring, and again, being as old as I am, I've been through this exhaustive process before in a case I tried in 1983, a death penalty case. We went through 400 jurors to get 12 in a death penalty case. Took 4 weeks to get the jury. So this will be complicated and we're going to, closer to trial, we would ask for attorney-conducted voir dire, but we would concede that's not allowed by the statute. But we're going to ask you to conduct individual voir dire of each and every juror with some very specific questions and allow us to approach you if we think there's additional questions needed. But everyone's going to know of this case, and everyone is going to perhaps have a preliminary opinion. The question is, can they put that aside and base their verdict on what you tell them and what they hear from the witness stand? So the second reason for Charleston is not only is it convenient, they've got a courthouse with 16 courtrooms in it. It's not going to shut down the county judicial system to try that case there. They did the Slager case there. Court operated normally, nationally covered case. Courtroom was packed every day, and it got a lot of attention. And right across the street, they tried Dillon Roof for 3 or 4 weeks. Didn't shut down the city. Now, to that suggestion, the Attorney General has suggested a number of other counties. But before I get to that, I'd like to address, and they have handed us an affidavit this morning, which
I didn't say I was admitting anything at this point.
you're not putting this in.
I didn't say I was putting that in. I just gave you that as a courtesy.
What are you going to do with it?
Waiting to hear what you do. It's your.
I'm going to say this is wrong. Are you going to put it in?
I'm waiting to see what you do.
Okay, well, I'm going to offer it. If I
Okay.
Well,
Sure, I don't-
object at this point. As a courtesy, I gave him an affidavit of our investigator that I potentially was going to admit, depending on their evidentiary presentation, and did that as a courtesy. Now he's going to put that in. If we're going to do that, that's fine. Let's go ahead and admit the real affidavit. But I just think that's.
Well, this isn't the real affidavit?
No, there's a signed notarized one. I just
Oh,
gave that to you as a
tell.
courtesy
Good, I'll put that in for you.
because I don't play ambush.
You gave it.
Okay, well, one of y'all needs to put it in. You could wait for Mr. Waters to put it in or Mr. Harpootlian.
All right, we would offer this as State's Exhibit 1 for
You're not
purposes
here.
of hearing.
You're not
Well, it's my affidavit. I would offer this as a State's Exhibit.
Probably out of turn, but go ahead, Mr. Harpootlian. It really doesn't matter who puts it in. It's in evidence as I would assume, Court's Exhibit number 1. Is that State's Exhibit number 1? You want it to be an exhibit or a court's exhibit?
We'll make it a
We'll
joint.
put it in as the State's Exhibit in support of our response. Again, Your Honor, I gave him a courtesy because.
And he just jumped the gun on you. Is that what you're telling me, Mr. Waters?
And I told him I didn't know if I was putting it in or not, but as a courtesy, I was going to go ahead and give that to him, so I wouldn't be handing it to him right in the middle of the hearing. But I was waiting to see what, if any, evidentiary presentation they made before deciding.
Mr. Harpootlian, he doesn't want you putting in his exhibits. So he's going to jump the gun and put in State's Exhibit number 1 for you. So could you?
He you get to see it.
Yeah, I'd like to see a copy of what it is y'all are arguing over.
As long as you're looking at it. Okay.
Thank
so
you.
And I can summarize, it's the same argument that he makes in his brief, that Charleston is too expensive. Although he didn't get an affidavit saying it floods, that he did put that in his response. So as to the flooding issue, we've checked. Nobody can tell us that court down there, other than during a hurricane, has been suspended in any way because of flooding. And of course, I'm sure the state will take judicial note, or you should take judicial notice, that galoshes or wellies, if you will, can be placed on your feet to get you through any sort of sodden street in Charleston to get to the courthouse. So I don't think that's a serious objection, although they made it. The major objection they have is it's too costly. So I'd like to call a witness, please.
Sure.
Bill Barber to the stand, please.
You want us to swear in Mr. Barber, the lawyer, on your side?
He probably would tell the truth anyway, but that's probably the safe process.
Raise your hand. Look in the Bible. Do you solemnly swear or affirm that the testimony you give before is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And Your Honor, as he takes a stand, their allegations are so ludicrous, I have to respond with my own ludicrosity, if you will.
Okay, go. Continue on, Mr. Harpootlian.
Mr. Barber, where do you live?
I live in Mount Pleasant, South Carolina.
And where do you work? Where's your office? We have an office in our...
I principally work in an office in downtown Charleston within walking distance of the Charleston courthouse.
Near Church and Broad?
It is on State Street near Broad Street.
Okay. And do you drive to work every day?
I do.
And how long does it take you to get from Mount Pleasant to basically 2 blocks, 3 blocks from the courthouse?
It takes 15 minutes.
Okay, and that's rush hour?
Yes.
Okay. Now, also, before you get on the bridge to come over the Cooper River Bridge, are there any accommodations that someone that was in a trial in Charleston could stay in?
Yes.
And just give us a sample of what those facilities would be.
There are, I believe, at least 9 budget hotels clustered at the base of the Ravenel Bridge on the both north and south of 17.
And you can get a room there at a reasonable price?
Yes, there's a Comfort Inn, a Holiday Inn, a Hampton Inn, there's an Indigo Inn. There are various, economy, extended stay suite. There's 9 of them total. There's everything you can imagine.
And there are more in the vicinity, correct?
Yes, and I pass those every day going to the office.
Now, when we tried this case in Colleton County, do you know where the state folks stayed? They rented a big chunk of a Hampton Inn, did they not?
They stayed at a Hampton Inn. I believe it was at the Interstate 95 interchange.
Okay. And do you know how, and if you Googled how long it takes to travel from that Hampton Inn to the Colleton County Courthouse?
I have not. I know that it took at least, I've driven it before. The Cracker Barrel was there when we went to there. It was it was a comparable 15-minute
Forgot
drive.
the Cracker Barrel was there. Yeah, it's about 15 minutes, right?
Yes.
About the same time it would take you to drive from one of those Mount Pleasant hotels, budget hotels, to the courthouse.
Yes, if you wanted to get in early, there's a lot of the hotels north of 17 have a highway on-ramp that's right there at the hotels without even having to stop late.
Okay, and then does the Charleston County Courthouse have a parking garage?
It does.
And if we went to the Charleston County Courthouse, do you believe that we could get some spaces set aside for the prosecution and the defense and perhaps even witnesses to park?
All I can say is it would be incredible to me if attorneys for the state of South Carolina could not obtain parking spaces at a South Carolina, judicial facility.
And does the state, there's a solicitor's office in the courthouse, is there not?
It's either in the courthouse or adjacent. There's actually a collection of buildings, so there's 16 courtrooms, in the actual judicial center, but that doesn't include, I believe, magistrates' courts have a whole separate building adjacent to it.
And so the solicitor's office would be available, the solicitor works for the Attorney General, right?
Your Honor, I object, and that's also legally incorrect.
I would answer no, that the solicitor does.
Well, wait a minute, he just objected. Be glad to hear from you.
Well, Your Honor, the only point I'm making is that solicitors certainly make space for a prosecutor from the AG's office to prosecute when they're down there doing statewide grand jury cases. I'm sure they cooperate with the solicitor's office. They're all in the same game. They all both are constitutional.
Well, I don't know that you know that to be true.
Well, that's been my experience. I was
Your
12
experience,
years
okay.
as a prosecutor.
If you want to talk about your experience, that's fine. I just don't want any testimony saying that's true if y'all don't know it to be true.
All right.
Go ahead.
So, based on your driving in every day and based on those hotels, do you believe it's a 15-minute drive from those hotels to the courthouse? Correct?
Yes, I pass the hotels every day.
And now this affidavit, you read this affidavit?
I have glanced at it.
And in the affidavit, their investigator says that there are no inexpensive hotels within walking distance of the courthouse, correct?
That's correct. I don't know all the hotels within walking distance of the courthouse are certainly expensive ones. I never really thought of that because, after all, when we were at Walterboro, no one stayed at a hotel within walking distance of the courthouse.
There are no
If we
hotels.
had a trial in, say, Richland County, I would imagine that the Columbia area prosecutors would stay at home and not rent a downtown hotel. So when I looked at hotels, I immediately thought of the 9 affordable extended stay hotels I pass going into work every day to the courthouse.
Which are within 15 minutes of the courthouse.
Yes. And I have Googled the price of those. I did that the day before yesterday, and different ones and different prices. The prices are not elevated because of the Masters tournament, because the Masters tournament, no one stays in a Hampton Inn below a bridge in Mount Pleasant to go a 6-hour round trip to Augusta.
Okay.
And the prices are comparable to Hampton Inns anywhere. They're not significantly more expensive, with the exception of sometimes the weekend prices are higher, or they're usually higher because you're near the beach, so there is some peak then.
They would go up on the weekend, but
It's the same price as any other Hampton Inn or Holiday Inn.
did we have any weekend court sessions in Colleton County?
When we were in Colleton County, everyone went home for the weekend. It was the only chance to go home.
So if there is an increase in price on the weekends, that would not affect the price they would pay during the week, anybody would pay during the week, including us. We may stay, actually, in one of those budget hotels. We're on a budget.
Yes. Yeah, presumably it would, the weekday prices would be what would be relevant.
Okay. I believe that's all I have for Mr. Barber. I'd like to continue with my argument. You want him to be able to cross?
Well, he might want to cross-examine him right quick.
Fine with me. Because of the affidavit thing, I'm sort of confused as to who's going what, when.
Would you like for him to cross-examine him now and then you can continue?
Yes, please.
All right, go ahead while I have him on the stand so I can let him down. Go ahead, Mr. Waters.
Thank you, Your Honor. May it please the court. Good afternoon or morning or whatever it is, Mr. Barber. How you doing today?
Good, sir. It's just in the afternoon.
Yep. When was the last time you stayed in a hotel in Charleston?
It's been a while. I will say that I had my best friend visit 2 weeks ago, and I put him up at the Hampton Inn that I'm speaking about, and I paid for it.
Okay. And you mentioned that there's a parking garage there in Charleston near the courthouse. Do you park there frequently?
It's been a while since I've parked there.
Been a while since you parked there, so you don't have.
I have parked there in the past, so I've
Right.
seen it with my eyes, but I haven't parked there recently.
Right, and so it is true then that parking garage is filled to the max very early in the morning, and it can be very hard to get a spot there. Is that correct?
I don't know. I will say this: I have parked there on occasion, not for just because it's a parking place, and it's been about 3 years since I've done this, but just as a place to park. And I remember one time I had to go to the clerk's office for some personal affairs. The probate offices are in there, and it is mostly full, but that's because it's mostly reserved spaces.
That's right. It's mostly reserved spaces.
For people who have who work, for the state of South Carolina.
And when you testified earlier, you haven't actually talked to anybody at the court administration or at the clerk as to who manages that parking garage as to how many spaces could be, if any spaces would be reserved for anyone. Is that correct?
I have not spoken to the clerk
Okay.
about the parking.
All right. You would agree that Charleston, on a larger scale, probably has the most big city traffic of anywhere in the state?
I would not agree with that.
All right, where do you
Personal
think
experience.
has more traffic?
If you've ever driven through York County, the Charlotte traffic going into York County, I would probably nominate that as the worst in the state.
Okay, so second then?
The traffic here in Columbia, especially around the what's called Malfunction Junction, but also coming in, when I do come into Columbia, sometimes I'm staying a little north and come in down Bull Street. That is a nightmare every day.
Okay, so you're saying the traffic in Columbia is worse than the traffic during rush hour in the Charleston metropolitan area?
I'm saying that it's worse than the traffic coming from the Ravenel Bridge side of Mount Pleasant into Charleston.
Would you at least agree with
I want to, if I can finish, you had a very broad question about the Charleston metro area. It's certainly true that if you're coming in from Somerville, right, down I-26 in the morning, that is extremely difficult. But I don't think that no one's going to be doing that. And I don't have experience with that. I've seen it. But coming from those hotels in Mount Pleasant every day to Charleston, it's a consistent 15 minutes.
Well, it was a simple question. You wouldn't say it's the worst, but you would agree that the traffic in Charleston during rush hour is a lot. Would you agree with that?
I would agree that it is typical of a city of its size.
Traffic downtown, particularly during rush hour during the business day, is a lot. Would you agree with that?
Honestly, it's a bit dead down at the Broad Street area. If you go up to King Street in that area, yes, but down where the courthouse is, no, it's really not.
Would you agree that parking is difficult in downtown Charleston?
I would agree that parking is difficult in downtown Charleston if you're not permitted to park in the, I think, 9-story parking deck that the courthouse has.
And you would agree that when you talk about spaces being reserved for maybe a prosecution team, that doesn't include witnesses and law enforcement and all of that would be necessary for the state to do what it did in the first trial, and that is to not let court break down once for 6 weeks. In fact, the only time court did break down was after 2 witnesses in the defense case. Is that correct?
Sorry, you were speaking fast. I didn't quite catch the question.
You would agree that if there are parking spaces being reserved for a large prosecution team, that doesn't include spaces that would be needed for witnesses and for law enforcement and that sort of thing, that would be necessary because the state has the burden of proof to prevent court from breaking down in a large complex trial.
No, if you're asking my agreement, I guess then my opinion is that the parking deck is available for people there at the behest of the state because it's the state's parking deck.
Would you agree that the Charleston area is one of the most expensive, just generally expensive areas in the entire state?
I don't understand what you mean. The expense of what?
Cost of food, cost of groceries, cost of hotels, cost of anything down in that area, as opposed to, let's say, Newberry or Lawrence.
I don't believe that the groceries are any more expensive. I've spoken to the hotels that I've spoken of are no more expensive. If you went to a fancy restaurant, they have more fancy restaurants certainly than most parts of the state does.
So you don't think the cost?
So that would cost more if you chose to do that.
You don't think the cost of living is higher in Charleston?
McDonald's is the same price in Charleston as anywhere else.
Can you listen to my question? You don't believe that the cost of living is higher in Charleston than in many other areas of the state?
I believe that it is because the real estate prices are higher, which I don't believe is relevant here.
All right. You mentioned something about people going home on the weekends. So do you know if all of the prosecution team went home on the weekends? Or do you know if they actually have to stay and work because they have the burden of proof for 6 weeks?
I have no idea what the prosecution team did over the weekends.
All right. Because, you would agree that a complex trial is pretty much a 7-day-a-week job. Would you agree with that?
Oh, absolutely.
Let me ask you this. Charleston, you would agree, has a lot of tourism. Is that correct?
Yes.
It's probably the premier tourist destination in South Carolina, or one of them.
one of them, certainly.
I mean, it's a great place, right?
Yes.
Most historic city we have, right?
Yes.
Okay. And Charleston has a lot of events, is that correct?
And what a lot means, there are several events during the year.
Okay. All right, and would you agree that the spring season is the busiest tourist time for downtown Charleston? Did you research that?
I would, the spring, the winter is less. Beyond that, there are tourists pretty consistently through the year.
Did you look at the fact that the weekend prior to the trial being scheduled, that there's the 50th anniversary of the Cooper Bridge run?
No, I did not look at outside the
Would you
trial.
agree that that brings a lot of traffic and a lot of people to the Charleston area?
It brings people to the Charleston area who run the bridge. The bridge is closed for a few hours on the weekend. I don't know about traffic, but it brings people in, certainly.
Did you also look at the fact that that very weekend as well, there's also the Creighton Waters tennis tournament in the area as well?
No, that's not anywhere near the area we're talking
You don't think
about.
that affects the traffic in downtown Charleston? Or in the Charleston area?
I've been to that tournament before. It's in Daniel Island. It's nowhere near. It does not affect the Broad Street downtown area.
Would you agree that that same weekend is also Flowertown in Somerville?
Somerville is very, very far away. I don't know what happens in Somerville.
So let me get this
It's a different
straight.
city and different county.
As a Charlestonian, you would not say that that particular weekend in particular, much less April and May, are not the busiest tourist times with the most influx of people than probably the rest of the year. You wouldn't agree with that?
No.
Okay. All right.
I can tell you, Seawee would be when the most tourists would be there.
Which one would be?
Seawee. South of the Wildlife Expo.
You would agree that the state has an obligation to try its best to be good stewards of taxpayer money. Would you agree with that?
Yes.
And you would also agree that the statute specifically states that in considering venue changes, that what must be considered is logistics and expense, and that at least one of those and most convenient one of those should be chosen. You agree with that too, don't you?
No, you added on what should be chosen. I do not agree that the state of South Carolina cannot afford to try a case in Charleston, South Carolina.
You don't agree that section 172185 says that in making a determination whether to proceed as allowed by this section or to order a change of venue for trial, the court shall consider all the logistical and expense elements and consistent with the demands of justice, choose a method that results in the least expense and greatest convenience for all parties. You don't agree that that's what the statute says?
They're consistent with the interest of justice, yes.
All right. And I understand consistent with the interest of justice, but would you agree that Charleston is one of the most logistically challenging counties in all of South Carolina?
Absolutely not.
Disagree?
Absolutely.
All right. And would you agree that Charleston, downtown Charleston, is one of the most expensive areas in all of South Carolina?
Again, that's a very difficult question to answer when you're not saying what's being purchased.
Food.
Depends on where you buy your food. As I said earlier, the same places cost the same amount of money. There's plenty of food. The McDonald's doesn't cost any more. The fast food costs what fast food costs. If you go to one of the many expensive restaurants, it will be expensive.
So it's your testimony here today that spending weeks down in downtown Charleston would result in no greater expense than if you were in many of the other counties of the state.
Absolutely. And to your earlier question about logistical difficulty, the logistically difficult counties are the counties that don't have the infrastructure to support the trial. You know, there was no place to eat. There was no place for us to stay, for example, in Walterboro, right? There were no hotels. There were hardly any restaurants. You know, you were bumping, there was a huge crowd. That's why they had the food trucks come out. Those were the logistical difficulties. I eat lunch in downtown Charleston every day. If you want to get a sandwich, it costs what a sandwich costs. It is not especially expensive.
Let me ask you one last question. would you agree that the United States District Court for the District of South Carolina recognizes the high cost of Charleston lodging in its reimbursement schedule and has a price of $380 per night, by far the greatest in Charleston from March through May? Would you agree with that?
I have not looked at the GSA schedule for their per diem.
But you wouldn't dispute what I just told you, would you? Would you
Say
dispute?
no, I'm not going to offer an opinion on what I would or wouldn't dispute. I haven't even seen it.
So you don't know, being a lawyer in downtown Charleston, that they reimburse by far the most during March through May in Charleston than anywhere?
What I know, based on being a downtown lawyer, is what it costs me to go get a sandwich. I know how long it takes to get to the office. I know how long it takes when I pass the hotels. I know what those hotels cost because I just put somebody up in one of them. That's what I know from personal experience.
All right. Nothing further, Your Honor.
Couple questions.
Briefly, Mr. Harpootlian.
Yes, ma'am. Mr. Barber, you heard the Attorney General ask you specifically compared to Newberry and Lawrence, right?
Right, Newberry.
Newberry and Lawrence. Newberry County has the same number of population as Colleton County, right?
Yes, we did.
Very small.
39,000 some people in each county.
Okay. And Lawrence is even smaller. So based on our experience in Colleton County, is your opinion, having been through that there would be sufficient jury members after we go through all the, remember now, that was before the conviction, before the movies, before the 6 books. Would that have an impact on our ability to obtain a jury in either one of those jurisdictions? Do you have an opinion as to whether or not there be sufficient jurors?
I think it's common sense that when you have a jury pool that is 10, more than 10, I think that would be 11 or 12 times bigger in a county, that you are proportionally 11 or 12 times more likely to be able to pull a jury. And I would also think that those considerations would carry more weight in picking a venue than it's how much the prosecution has to pay for a Hampton Inn.
And do you understand that the solicitor for those 2 counties is Mr. Stumbo, who will be the new Attorney General in January, and his boss, and has been the elected solicitor from those counties for about 20 years. Do you understand that?
All of that, except I didn't know it had been 20 years.
And that he would have had the ability to, running for re-election, to have a much more knowledgeable and relationship with jurors than we would ever have, than Mr. Murdaugh. In other words, he would have, it would be home cooking to have him doing that in those counties. Don't you think?
I honestly don't know what happens. I've never driven through Lawrence, but I would assume that the local prosecutor, who's been there for 20 years, has tremendous knowledge of the local population.
Okay. Thank you. I have no further questions.
Nothing further, Your Honor. I would like to commend Mr. Harpootlian on going ahead and conceding the election, the general election in November.
Can I excuse this witness?
Yes, ma'am, Your Honor.
All right. Now, let me ask y'all something, because here we are talking about counties and where we're going. Am I correct in assuming that y'all have agreed to transfer venue from Colleton County, and not only from Colleton County, but out of the circuit?
No, Your Honor, we have not agreed to that, as our motion states. And again, I don't want to jump the gun. I'm responding to Your Honor's direct question. But of course, our point was we actually tried to negotiate without conceding anything, and we're essentially told Charleston. And there were no other counties that they were willing to consider.
So are you telling me that you would have conceded had they picked somewhere else?
I said, just as I said in my motion, that I'm always happy to have a reasonable discussion. What I can't do is just have the defense dictate the most expensive and what we consider the most logistically difficult county in the state. That's the point that we're making, and that I think I put in my motion as well. We're happy to have discussions. Absolutely, the state has an interest in picking a fair and impartial jury as much as the defense. And despite what he says, the state is entitled to a fair trial as well. That says in our appellate opinions all the time. I want to get somewhere where we can get 12 in a box and get a process that win, lose, or draw is going to be one that sticks. And that's the state's goal.
Okay, all right.
Based on his filings and our discussions, I'd assume that we were going to leave the 14th Circuit. First of all, if you want me to walk through the rationale Judge Kelly had in his order he issued yesterday, I'll be happy to do that. But I think our filings make it very clear.
I've read your motion, I read your memorandum in support, and then I read the state's response. Then I read your response again that you filed with the court. I've read it all. But if you would put your position on the record for me.
Okay, well, the 14th Circuit, which is Colleton, Jasper, Beaufort, and Allendale, is where the defendant is from, where his law firm has operated for 100 years. The Murdaugh name is well known throughout that entire circuit. And so that circuit, the movies that were filmed, the 5 movies that were filmed in Colleton, Jasper, and Beaufort. The Murdaugh case is a local freak show. You have people being interviewed on the street in all those counties, commenting on whether they thought he was guilty or not, or whether this happened or that happened. I mean, it was so outrageous that Buster Murdaugh is suing Netflix for accusing him of murder. That's a civil case that's going on in Hampton County. So there's no, I mean, do we have the money to have some sort of poll or do what they did in the Parker case? No. And that's why I want to rely on what they found in terms of their ability, Parker's ability, to get a fair trial in this community that's permeated with this pretrial publicity, the movies, the books, 6 books on this, and many written, a couple of them written by folks down there other than the clerk. So,
And I also read in your motion, Mr. Harpootlian, that there were fewer than, correct me if I'm wrong, fewer than 1 in 7 prospective jurors were qualified to serve. That was during the first trial.
Correct. Before the conviction, before the movies.
Exactly.
Before the books.
And before Becky Hill.
Before Becky Hill.
Which is something totally different, but also very prejudicial to the defendant, would you not say?
Your Honor, I concur completely. And so Colleton County is poison. I don't think he, with a straight face, the state would argue that we should go back to Colleton County. The courthouse, no offense to my friend the clerk over here, but the courthouse is the scene of the crime. We can't go back there. So once you get that out, Allendale and Jasper are smaller than Colleton County. In 1 out of 7, if that, and I think that's probably what's going to happen in that entire circuit. In Beaufort, Beaufort is a county where their firm operated. He's well known, and he's a local guy, and so he's vilified. He's convicted of murdering his wife and child. It's horrendous. Stealing $12 million. Horrendous. And so, but he's entitled to a jury that can put all that aside and base their verdict on what you tell them and what the witnesses say. And that ain't going to happen in the 14th Circuit. That definitely ain't going to happen in Colleton County. And it would be an exercise in futility to go down there, set up all the infrastructure, and try to pick a jury. After 3 or 4 weeks of not being able to get a jury, or people, most normal people would run like a scalded dog from this case, because it could be 3 weeks taken away from we're not moving for sequestration, taken at this point anyway, taken away from their family and their jobs. No rational person wants on this jury. And that's going to be tough, especially in that community. And now I'm not telling you that we go to, and we say Charleston, that there won't be a huge number of people who know about it and have made up their minds. But if you have a potential...
Well, that's due to all the publicity.
Due to all the publicity. It's just that we're going to have a huge... We went through 400 jurors in the Gaskins case. 400 before we could get 12. And it took 4 weeks. And so I've watched this process. And if your honor's voir dire is as incisive as I believe it will be, folks will come off the, well, you know, yeah, I think he's guilty, but, you know, I could give him a fair trial. Or, I know all about the case. I watched all the movies. I've read all the books. But you know, I can put that aside. I mean, that just doesn't, I mean, somebody like that should not be allowed on the jury. And we're going to see many, many, many more of those than we saw in Colleton County 5 years ago. Now, their counter is Charleston's too expensive. There's no evidence in that record that you can't get accommodations within 15 minutes of the courthouse that are the same as you'd pay in Gaffney. That's number one. Number two, the convenience to getting there, it's 15 minutes. Number three, he says, well, we don't know we're going to have parking allocated by the clerk down there or by the court. You know, this morning, Mr. Waters and I drove into, we had 2 reserved, I think he may have had more, 2 reserved parking places right out in front of the courthouse. It happens. That's what happens. So, yes, they can accommodate the parking, the drive, cheap hotels. I mean, he's asking, and by the way, if it did cost a little bit more, let's say it did, he has a right to at least have access to jurors who haven't made up their mind, who have read about it perhaps, and could honestly say to you, you know, I haven't made up my mind. I'll listen to you and the witnesses and follow the charge. And that's the acid test. Not whether you're going to have to pay $20 a night more a night there than you would in Newberry, where the solicitor there is going to be prosecuting the case, or Lawrence. I mean, it's and of course, we would say to you, we need a big county, not a small county. We need a big county. So you're basically limited to Greenville, Columbia, and Charleston in terms of the jury pool. Greenville, for all the witnesses, would be, every witness would have to spend the night. Colleton is 45 minutes, Walterboro's 45 minutes away from Charleston. Witnesses can drive over at 2:30 in the afternoon, testify, and drive home. So the cost of putting witnesses up is gone. If you have an expert witness coming in, very easy to get them into, I mean, of course, we had the problem in Walterboro, no airport. They had to fly into Charleston, drive down, fly into Savannah, drive up. So you need someplace that has good access to airports, because we're going to have several out-of-state experts. I'm not sure what experts they're going to use. So Greenville logistically doesn't work. And by the way, if you're going to stay at a Days Inn in Greenville, they're charging the same price in Mount Pleasant. Same price. And of course, if you are looking for a jury pool where you can find those 12 or 14, however many alternates you're going to have, the bigger the panel, the easier that will be. If you use that 7%, let's say it's 5%, if you summons 1,000 jurors, which you could do in Greenville or Charleston or Columbia, and 5% are qualified, that's 50. We can get a jury out of 50 people. But you go to one of these small counties, you can't get I bet you can't get 1,000 jurors to show up. It's been my experience in the rural counties are a little less willing to come in, and they don't want to be gone for 3 weeks or 2 weeks from their jobs. And I mean, it's going to be tough. Getting a jury in this case is going to be extraordinarily difficult. Why make it more difficult by limiting your choices? Why make it more difficult? Because, and again, there's no tactical advantage to us in Charleston. He's not from Charleston. I'm not from Charleston. The Charleston is going to give us a larger jury pool that's more accessible to 30 or 40 witnesses in this case from Colleton County. So when you look at the cases on this issue, they all come back, and I understand they have a right to a fair trial too, but he has a Sixth Amendment right to a fair trial. And that Sixth Amendment right means, and let me say this to you, you know what else you get with Charleston? no appeal. I'm putting on the record, if you give us Charleston, we will not appeal the venue issue, ever. Take that one off the plate. Not that
You're
you,
requesting the change of venue.
I know.
Just want to make sure I've got that right.
If you deny the motion for change of venue, we're going back to Colleton. So I don't really think, and correct me if I'm wrong, that that is a viable alternative. I think we've got to move it somewhere. And we're suggesting Charleston because we think that will be the most expeditious way to get a jury that truly has not made up their mind.
Okay.
Now, he's arguing cost. I heard him. He's trying to get Mr. Barber to say Charleston is expensive. And when I'm there, not on business, well, sometimes on business too, I stay at really nice hotels and eat in really nice restaurants. But we won't be for this. He's broke. He hadn't had a job in 4 years. And if he did have a job, the feds or the state would be seizing the money. So, and we have and let me say this, we have an office in Charleston within walking distance of the courthouse. So that makes it more economical for us and allows us to have the money to hire a DNA laboratory in Texas. And we're going to have to hire other experts from outside the state. And we want to put our money into that, not having to stay somewhere else or even paying for witnesses to have to come somewhere else. Now, our memo talks about, all kinds of things and the factors. But, Your Honor, first of all, I would say to you, if he gets up here and argues we need to go back to Colleton County, then he is, and I don't know why he would do that. I have no idea why he wants to go back to Colleton County. Maybe it's his lucky courthouse, but it's not rational and compared to what his Sixth Amendment rights are.
Okay.
Happy to answer any questions you have.
Thank you. All right, well, let's hear from you, Mr. Waters.
I apologize.
Your Honor, I want to start out by saying, and the state was in a leadership position prior to the first trial in putting together logistics, doing things like asking for a gag order in order to try to do exactly what the state wants, and that is to put 12 in the box who honestly can be fair and impartial to both sides. That's been our entire goal the entire time. This is as I wrote in my motion, this is the world we live in, and the genie is out of the bottle. And I'm not going to sit here and not say that this case has been unique, almost nationwide in the amount of publicity that has been generated. And so that is going to be something that's going to be overcome. But the law is very clear that the remedy for that is, of course, an effective voir dire process. And we put together a good procedure last time. It was very efficient. It worked, even though the frenzy was out there then too. I want to be clear that I'm here to be reasonable because as I said before, I want to pick a jury that win, lose, or draw will stick, and that we have a fair to both sides. And I believe that we can do that. But the issue, of course, is not pretrial publicity. Long gone are the days where people got their news from the evening paper or the morning paper, and it is ubiquitous out there. So we're going to have to rely on our citizens and identify those citizens who can put whatever they may have heard aside and honor their oath to be fair and impartial. I also want to be reasonable here when I say that I'm happy to consider any other option, but I also am a steward of the taxpayer money. And the statute also requires the least logistical expense. I also, as I said before, we didn't let court break down for 6 weeks, and it was a logistical, huge effort that I give credit to a lot of these staff members back here and keeping one witness coming up after another to get this thing going. And so I'm thinking about those things, and I have been in court. I love Charleston. Charleston is one of my favorite places in the world. I have been to court down there many a time, and it is always a logistical difficulty. And to contend it's not the most expensive city in the state, I don't know what to say to that. So I have to at least not be, when the defense says Charleston or nothing, I have to at least say, Your Honor, there's problems with that, and we believe that there are other choices in the state that would be better, of which I am happy to talk about and consider those other choices. That's been the state's position. In the end, Your Honor, all I want is a fair jury to the state and to the defense, and have us be able to present our case to citizens who are going to abide by their oath and be fair and impartial to both sides. And that's the process that we're looking to have happen.
Okay, thank you. Anything else from the state? Defense. I'm sorry.
I have so much to say, but probably not. Thank you, Your Honor.
Thank you, Mr. Harpootlian. All right. I understand. It sounds to me like y'all are just agreeing to disagree. Y'all just want, each one of y'all want a different place to hold it. But let me tell you, I read your motions, and I took them seriously and went through and did some work on them. And I'm going to tell you, after reviewing the motions submitted by both sides, I even went back and looked at the transcript of the jury selection that was conducted back in January of 2023, and also the opinion from our Supreme Court. I'm going to order that venue be transferred to a county outside of the 14th Judicial Circuit, because I believe that the defendant cannot receive a fair and impartial trial in Colleton County. I'm making this ruling in pursuant to the South Carolina Code 172180, and it's supported by case law. That would be State v. Law, where the circuit court retains the power to transfer venue outside of the circuit where a fair and impartial trial cannot be had. So I'm transferring it not only from Colleton County, but out of Colleton County completely. I find that the defendant has satisfied his burden under State v. Manning, where he's demonstrated actual juror prejudice. And unlike the ordinary pretrial publicity case, the evidence before this court is based on the actual results of the voir dire conducted in this case in the January 2023 trial. Fewer than 1 in 7 prospective jurors were qualified to serve, demonstrating an extraordinary degree of community exposure and prejudice. Second, under Reamer versus U.S., the interference with the jury process by an officer of this court is deemed presumptively prejudicial and cannot be measured by any voir dire. Ultimately, the decision to change venue lies within the sound discretion of the trial court, providing that a showing of actual juror prejudice is made. This ruling rests on 4 grounds. First, the exceptional rate of juror disqualification during the January 23 jury selection. Second, the community prejudice arising from the size of the county and the long-standing association between the defendant's family and the 14th Circuit. Third, the South Carolina Supreme Court's determination that the former Colleton County Clerk of Court improperly influenced the jury, depriving the defendant of his constitutional right to an impartial jury. And fourth, the form of publicity surrounding this case. There's case law that says I can't transfer something just for publicity. That can be cured. But with the 4 grounds that I've just stated, I am transferring it. Further, this ruling is supported by the court's recent order in Beach v. Parker that I just read yesterday that Judge Kelly, I was interested in his order. I did go read it. There, the court found that the moving party made an affirmative showing that a fair and impartial trial could not be had in Hampton County due to the extraordinary pretrial publicity and the surrounding litigation. The court concluded, other than publicity, the settlement of the wrongful death action, the criminal prosecution of Mr. Murdaugh, the defendant in this case, including his reversal by the clerk of court. The same publicity and public attention that justified transfer in Beach is present here and further supports this court's determination of a change of venue is necessary to protect the defendant's constitutional rights. Further, I'm going to find that under Section 172185 is not an adequate alternative. That procedure would require Colleton County to bear the substantial cost of transporting, housing, feeding, and securing an out-of-county jury throughout a multi-week trial. More importantly, it would not remedy the prejudice identified by this court or eliminate the concerns arising from retrying this case in the same community where the constitutional violation occurred. I find that there's no lesser remedy that will adequately protect the defendant's constitutional right to a fair and impartial jury. The court rules venue is transferred outside of the 14th Circuit. I'm going to reserve my ruling to the specific county in which this matter will be transferred. You know, let me tell y'all, it takes a village to get this case transferred. For those of you who don't know, there's a lot of other things besides walking into a courthouse and sitting down and trying to try a case. You know, we have to consider security, transportation. Is the courthouse adequate? Is there lodging? There's also docket considerations that have already been set for next year. There's a bunch of matters to consider. So what I'm going to do is I will think about it. I need to look at it. I will tell you, Mr. Waters, you are correct. Cost is a concern because Colleton County does bear the cost of the retrial in this case. Colleton County is not a rich county. It's a poor county. So that will be at the foremost of my thoughts when I transfer this case. I was in hopes that the two of y'all could agree on a destination, but since that's not happening, I will decide and I will let y'all know. I will issue an order. I will do a formal order on my transfer of venue and also will designate the county into which we are going to try this case. Okay? Any objections?
None from the state, Your Honor.
Perfect.
Thank you, Your Honor.
You're welcome. All right. Now, the last motion, Mr. McCullough, I know you've been sitting here since 10 o'clock. If you could come up and just for the record, state your position. I believe I've got, Mr. Waters, I believe I have your stance on this, but I'll get you to put it on the record and let me rule, please. Go ahead, Mr. McCullough.
Your Honor, the benches are hard and life is short, but I wouldn't have missed the Charleston travel log for anything.
I wish I would have. Go ahead.
Your Honor, I don't want to detail I'm here representing Myra Crosby, a former deposed jury in the criminal trial, which you're obviously familiar with. And given your nature of preparation, I know you've read my initial filings. If you have any qualms about how this matter comes before you, I will streamline that by simply saying that following the plea of Ms. Hill in December of 2025 During that proceeding, Solicitor Hubbard, who was placed in charge of the investigation for jury tampering, indicated the case was closed, no charges would be filed. From that point, shortly, several months after that, in March and then again in May, we filed freedom of information requests for the jury tampering investigations, which were closed and therefore no longer susceptible to any exception under the Freedom of Information Act. And we sent that to SLED, the Attorney General's office, and to Mr. Hubbard's office, Solicitor Hubbard's office. In response to that motion, I think it is correct, and I don't want to preempt, but Mr. Waters is here, General Counsel for SLED is here, and I spoke to Solicitor Hubbard outside to just confirm their positions are not in opposition to the remedial attention to the protective order, but they do say that they all three, as agencies, are constrained by protective order, which includes at least, if not is, the protective order of Justice Toll from January of 2024, issued preceding her new trial motion hearing. At that time, she issued a protective order, which I think the primary concern was to protect the identity of the jurors in the case that may have been to some extent interviewed in whatever jury tampering investigation led up to that point, January 24. And of course, that investigation continued after that hearing, after January 24. So we are simply asking, and there was no other way to get here, Your Honor. We originally filed a motion to intervene, to have a court review the protective order to determine that those issues were now moot, and at least the issues that Justice Toll addressed, or the reason, as I read her protective order, for constraining any release of investigative materials relative to jury tampering. Now, there's been a little confusion. The in-camera proceedings, I am not seeking the release of, because I have that, but I am constrained by the order of Judge Newman. I was allowed to have them, but I can't disseminate them. I'm good with that, and I don't think those aren't the issue today. So I wanted to eliminate that confusion. I'm here today simply asking, Your Honor, pursuant to the Freedom of Information, and you know, the purpose of the FOI is to simply make it possible for citizens and their representatives to learn and review the activities of their government. And secondarily, Ms. Crosby asked me to pursue this because she wants to see the quality of the investigation. She wants to evaluate it. She believes the public should be able to evaluate it. She is hopeful that it will lead to additional information in support of her belief that she was targeted through an orchestrated effort to remove her from the jury. So for all those reasons, Your Honor, I believe that it's appropriate for me to be before you as the assigned judge for all things Murdaugh, and to ask you to review that protective order and any others that could be referenced that I'm not aware of, and to conclude.
You're not asking for any jurors' names or any kind of identity.
But that's the worst kept secret on the planet. I think that half of the jurors went to New York and appeared on the Today Show, I think.
Well, I understand all that, but you understand
I'm not
as a
opposed to
court,
redactions.
as a court, you know, we protect our jurors. Now, whether they want to get out and go dance on ABC and tell them everybody who they are, that's fine.
Your Honor,
But I'm not comfortable in unsealing any identifying factors for a juror or a juror's name.
not asking for that, Your Honor. And
Okay, just wanted to make sure.
I respect the position of the Attorney General's office, which actually filed the only responsive pleading. So I respect that. My only concern is simply this. When you begin redactions, I do not want to have to be back here or through the Freedom of Information and a lawsuit complaining about Epstein proportionate redactions. Protecting the identity is one thing, but I don't want to get pages and pages of blacked out, redacted.
I understand.
So that's our position.
Okay, Mr. Waters?
Thank you, Your Honor. First of all, as we detail in our response, there were multiple protective orders during the course of this. And
Right.
of course, the first thing we have to talk about is what you just recognized, is that the court promised those jurors over and over again, both Judge Newman and Justice Toll, we're not going to release your identity. And we deal with this all the time. Just because I might be subject to state grand jury secrecy doesn't mean somebody who's subpoenaed can't go run their mouth about it. And I still can't run my mouth about it, right? Except as necessary in court. So, and so the other thing is that we also wanted to protect, of course, ongoing investigations, which have resolved at this point. And so that's why we have filed a motion to unseal. However, our motion to unseal also includes the sealed portion of the initial inquiry that got that juror kicked off the jury. Okay, and that's important that come out. In fact, I find it interesting how Mr. McCullough says he wants the public to judge what happened, but he doesn't want them to see what was the basis for the exclusion in the first place. And so there is that needs to be unsealed at this point now. There's no reason to do that. Of course, redacting identities, and that, of course, is the only limitation that we have, is that those juror identities be redacted. The main difficulty in that is there are some MOIs. Those are easily redacted, and other personal identifying information that are normally redacted to protect people's privacy. The MOIs are going to be easy to do that, memorandums of interview, but they are summary documents only, and there were of course body cams of interviews and that sort of thing, and so that's going to be a little bit more difficult. It's going to take some time to do, but subject only to that, to honor the court and frankly the state's promise that we won't be the ones to release your identities. We believe that not only should the sealed inquiry at trial be released, but also within the appropriate bounds of FOIA and subject to redaction, the investigative file as well.
Okay.
I would only respond by saying that with regard to the in-camera proceedings, we're not asking for that to be unsealed. I find it fascinating that the Attorney General's office is. I don't know how you're going to redact the identity of the person that everybody in the universe knows was the object of the in-camera proceedings and the only person who was removed from the jury. But I certainly will respect your ruling.
Well, if someone else decided to run their mouth and go to the media, then that's on them and ain't on us. I would also point out, Your Honor, that Mr. McCullough on June 24th, June of 2024, requested unsealing of the in-camera proceedings and then filed on September 4th, 2024, a petition to intervene with the Supreme Court to seek it unsealed. So on multiple occasions, he has requested to have it unsealed. So,
and I achieved my goal, which was to have access.
Look, I like for everybody to know everything. So this is the deal. We're going to unseal it. We're going to protect the jurors' names. I want that redacted. I want any identifying information concerning a juror redacted. Unseal the rest of it.
Thank you, Your Honor.
that's exactly what the state wants. Thank you, Judge.
Thank you. All right, now with all that done, let's talk about when we shall meet again. Already, yes. I'm telling you, I'm keeping us on schedule. We're going to get this done. My 2 dates for my next hearing. And let me just tell the lawyers this. I did have a motion to exclude evidence. And the state's motion to admit evidence of motive. And that's going to involve the financial transactions. I think a ruling at this time would be way too premature. I want to be closer to trial. I probably will not even consider those motions until the beginning of next year when we start doing pretrials. However, Mr. Harpootlian, your motion to dismiss, I was told I would be getting a supporting memorandum, which I do not have. I pushed that out because the state hasn't been able to respond to it, because they haven't been afforded the opportunity. They don't have it. I will push that out to the next pretrial hearing. I do not want the DNA, Mr. Griffin, to wait that long. Because I'm thinking either November the 13th or November the 20th. That would be here in Lexington, again at 10 o'clock. That way I can address any other matters that might come up. Any of those, do those dates work for y'all? I know it's close to Thanksgiving, but I was trying to get it in so I won't bother you over Christmas, because I'm going to start bothering y'all again in January.
The 13th would be far preferable to us because, so I'd have all my staff available and everything for that.
Okay. How about you, Mr. Harpootlian?
What was the first date, Your Honor?
The 13th, November.
November, well, okay, let me look. Wrong month. Friday, that's a Friday.
The 13th?
Yep. Friday.
Oh, gosh, is it really Friday?
That's
Well, I
perfect,
didn't
Your
mean to
Honor.
do that.
That's perfect, actually.
The way things gone, that's our lucky day. That'll be fine.
Okay. Oh, that's too funny. I'm sorry. I did not realize that was Friday the 13th, but I'm not superstitious. I hope you're not. All right, November the 13th, 10 a.m. is going to be our next pretrial. We will take up your motion to dismiss. Please have your memorandum filed timely. Let me say timely, because I was working the weekend. I get 18 motions at 5:15 on the 7th. That was fine. Then I've been getting motions all week long. And that's fine too. I understand y'all are busy and you have stuff to do, and but please try to be timely. So I'm going to tell you before you say that, Mr. Harpootlian. Let me see. Deadline, the Friday before. 11/7. It's going to end on a 7. All motions that you would like for me to hear that day, please have them filed.
Your Honor, may I make an inquiry?
You may.
The problem this week for, I think, us and the Attorney General, is we filed a bunch of stuff, motions last Friday.
And we got
And
responses.
we had to do responses. So if perhaps you would
Set it up?
maybe move back a week
Sure.
for the motions, and then give us a week to respond, and then if you want to file some sort of reply, do it at your own risk.
All right, how about October the 30th, which is a Friday. It's the day before Halloween.
Yeah, Halloween and Friday the 13th at this point.
Well, why not?
Why not?
Just to have your motions in, then y'all can respond the following week, and I'm putting my deadline for the 7th. Yes, response deadline will be the 7th.
So 30th, first,
File your motions,
30th.
response by the 7th. So I'll have time. I mean, believe it or not, y'all, I really do sit down and read every motion that y'all file.
Would you like us to shorten them a little bit?
Always. The shorter the better. But I do read all of them.
I think the 6th is actually Friday, Your Honor.
It's 11/6. 11/6. All right. Anything else from the state?
Not at this time, Your Honor.
Anything else from the defense?
No, Your Honor.
All right, Mr. Griffin, you're going to let me know. Now, let me ask y'all about this. When he does let me know about the DNA, because I want to be on this. It's going to be long before November. Is it possible for us to have a quick hearing so we can decide what to do with the DNA?
Sure.
Yes, Your Honor.
Absolutely, and again, once we get that, I'm happy to
It's
work
hard
with
for
them.
me to set a date until I hear from Mr. Griffin, but maybe we could set a date, and once he calls me, and I'll email y'all a few dates, and maybe we can have a quick hearing one Friday afternoon or something.
Your Honor,
Go ahead.
you know, we need the transfer of the material from SLED Lab to Othram. That's chain of custody, we're out of it, but nothing can happen until that transfer takes place.
Well, and I'm gonna talk with them about that, but thought that he represented to the court that they were gonna agree and not challenge chain and accreditation issues and that sort of thing.
We're not.
And then secondly, we'll work on that.
Are y'all gonna let me ask, turnaround's fair play, are you gonna challenge any, chain of custody on him?
Not if we agree to the procedure and my scientists are okay with it, then there would be, unless, shenanigans happen.
Okay, well, let's,
I did say shenanigans. But I would also add that, just to be clear, it's still the same deal that I offered, that they're gonna process in quant and then stop, and then we'll find
stop.
out.
That's exactly right. You understand that, Mr. Griffin?
Absolutely, and we're coming back to the court.
I'm gonna put it all in one place,
Right.
let you process it, then you're gonna contact the court. You're stopping. You're not doing any test until we know. And we're gonna have a hearing on it, a quick hearing. It won't take long. You can tell us, is there gonna be enough reserve for the state?
Correct. I just want to be clear, we're talking about the unprocessed material.
Unprocessed and the leftover is going.
It's going, but can we go ahead and test the leftover?
We're okay with that, Your Honor. They can run the leftovers. It's the unprocessed that we need the results on.
Okay. You don't need both of them to do the test?
I'll talk to the lab, I'll talk to Dr. Middleman, so I'll find out. But, we want to get this thing going.
Okay, well, I'm just telling you, before you do any test whatsoever, we're gonna have a hearing.
Okay, we won't do any testing.
Just go ahead, get it quantitative.
And I guess one last thing I would ask is that by doing this procedure, they're waiving any claim under the Preservation of Evidence Act, at least as to these items.
Well, I mean, we have to, because if it's destroyed during it, I don't find that to be willful. I read the Preservation Act, and I don't think us doing this is in anything intentionally on either side to destroy any evidence, which, you're obligated to uphold. I don't see that. So the court doesn't find that to be a problem. I mean, if it gets destroyed, y'all understand it's destroyed. Okay. All right. Thank y'all.
Thank you, Your Honor.
Court's adjourned.
Thank you, Your Honor.